hearing in the appeal Grove Park Developments Limited and the Mauritius Revenue Authority.
Mr. Boulel.
May it please your lordships. I appear with my friend Christel Basuramen for the appellant company, instructed by ENS Africa Mauritius. Mr. Philip Baker QC, Mr. Rajesh Ramlal SC, and Mr. Imran Afzal appear for the respondent, instructed by Lloyds Witherking.
Yes.
My lords, this is an appeal against the decision of the Supreme Court of Mauritius, which was delivered on the 23rd of October 2015 and upheld the decision of Mauritius Revenue Authority to the effect that the appellant had not satisfied the requisite conditions of Section 161A of the Income Tax Act to benefit from exemptions from payment of registration duty and land transfer tax. My lords, the consequential tax liability of the appellant is in the order of around £1 million. Right. From the appellant's perspective,
does that include the penalty?
I'm sorry, my lord?
Does that include a penalty?
Yes, my lord, including the penalty.
It's $1 million in total, yes.
Yes, my lord. The two issues before the board from the appellant's perspective are, firstly, did the appellant comply with the conditions of Section 161A 28B of the Income Tax Act to meet the 50 million rupees threshold? The answer to this, from the appellant's perspective, is yes. The second question is, did the MRA act properly as a statutory body in refusing to allow the appellant to benefit from the fiscal exemptions under the additional stimulus package?
Is that a different question from the first? I mean, suppose that the answer to the first question was against you. Could you then succeed on the second?
Possibly, my lord. But I think it's a question of making sure that the appellant hedges its bets on both fronts to make sure that if, for argument's sake, this board was to find that the cost of construction was to be assimilated to the materials on site was to be assimilated with the cost of construction, and there was a correct construction of Section 161.28.1b of the ITA, then the question would still arise as to whether the MRA, independently of that finding, had acted properly.
So even on the footing that the condition had not been satisfied, you say that you can resist the payment of the tax and the penalty?
The point being that there are separate issues as far as the appellant is concerned. With your Lordship's permission, I would like to I do not propose to repeat everything that's in the written case for the appellant, which is found at pages 346 to 385 of the record. I would, however, propose to concentrate on 4 areas of discussion today. The first one being the additional stimulus package and the role of the MRA under Section 161A, subsections 27 to 33 of the ITA. The second one being the decision-making process of MRA. Third one, the meaning of costs of construction. And the fourth, possible implications of a time lapse between the final hearing of a case and the date of judgment on the findings of the Supreme Court. Starting with the additional stimulus package, my lords. The background to the need to have an additional stimulus package is laid out in the additional stimulus package document itself at tab 24 of the list of authorities. This is, my lords, the very core document we are concerned about here, which is basically the promise, as I call it, made by the state to the taxpayer. The document is called Additional Stimulus Package, Shoring Up Economic Performance. It is dated 20th of December 2008 and the period of application of the additional stimulus package provisions is stated to be 1st of January 2009 to 31st December 2010, which is a very short window of 2 years, my lords. At page 771, the introduction states the origin of a problem. I will not read it, but it is just, it paints a very bleak picture of what the world economic scene looked like in 2008.
Yes.
The main features of the package are listed at page 778, my lords. And it comes out as a 9-point explanation of what the package is to be. The ones that concern us are really the fact that it's meant to be a targeted, flexible, and temporary provision. And the fifth one, we're dealing with bottlenecks to boost private investment and, where possible, accelerate their projects. Seventh, support will be provided to businesses to continue operations so as to protect employment and workers. And of course, ninth, the government is providing ample protection for the population during the period of international crisis. At Part H, page 800, Part H deals with the avowed intention and aim of protecting the population. And I would suggest a look at page 803, which to me is an important reference. At the top of the page, the first paragraph, yes, which describes the package as a social contract, which I understand, my lords, to be a voluntary submission to making certain sacrifices here, protection of employment, lowering of prices, and injecting funds into the construction industry.
It might be said that the terms of the contract, that's the intention, but the parties are then bound by the terms of the contract. You then have to look at the contract.
Yes, my lord.
It's a statute.
Exactly, my lord, yes. And again, the promise was of lighter fiscal burden.
You seem to be leaving the package, Mrs. Boulel. I wondered whether we ought to look at 797 before you did so.
Yes, it's the third full paragraph, which is a description of the particular element of this package that is,
yes,
that is relevant in this
yes,
case.
It is. I had put in the written case, and I will repeat it for your lordship's benefit. I look at the paragraph halfway down the page.
Measure.
I'm sorry, my lord?
As an exceptional measure.
Yes.
That's right. Yes. As an exceptional measure to help the construction industry, the land transfer tax. Perhaps I would start at the paragraph just before, my lords. I think it gives context. To give additional support to the construction industry, duty on iron bars in coils imported by registered contractors will be reduced from 15% to 7.5% from the 1st of January 2009. As an exceptional measure to help the construction industry, the land transfer tax and registration duty will be suspended for the period of 1st January 2009 to 31st December 2010 for approved projects undertaken by developers to be registered with the AMRA in respect of land for a development project, provided at least 50 million rupees worth of construction works are completed before the 30th of June 2011. This measure will not apply to IRS projects, and land transfer tax will be allowed as a deduction for income tax purposes.
Yes. So what the public was given notice of there was that there was likely to be in the legislation a criterion that 50 million rupees worth of construction works had to be completed.
Yes, my lord. Yes. Perhaps as an advance notice of what my submission would be on this matter, perhaps I would just say that although the legislator would eventually put those provisions into the Act, as in what construction works completed, yes, would mean.
Well, clearly we're not concerned with interpreting those words when we look at the legislation. But insofar as the public got notice of what was intended, that is what they saw.
Yes, my lord.
Yes.
And you accept that in that context, completion means actual building, not just having materials on site?
No, my lord.
Don't?
No.
Accept it.
No. My submission on this, my lord, would be that the terms used here are construction works, 15 million rupees worth of construction works completed before a date. My submission on this would be construction works is not a plain, ordinary English term. Construction works is something that is measured.
Yes.
And the
Well, I
measurement-
understand your point, that one has to look at how the quantity surveyor
Yes.
does it. So you say that even in this context, where it uses the word completed, nonetheless, having the materials on site is good enough if that's what the quantity surveyor certifies.
Absolutely, my lord. And I would add to that, that the word we're actually concerned with is not completed.
Yeah.
The word we're concerned with, and which appears throughout the text of the law, I'll submit on this later on, is the term cost.
I see.
So, if the entirety of the materials for the whole construction project had been delivered to the site the day before the deadline, but nothing else had happened, you'd say that the conditions would be satisfied?
No, not exactly, my lord. I would add to this that if the material had been delivered and there had been proof that expenditure had been incurred.
Well, let's suppose that 100% of the building materials required had been delivered to the site the day before the deadline and paid for. So the conditions satisfied or not?
Yes, my lord. To the extent that materials on site are obviously going to be used in construction works. Construction industry being the way it is and the way it operates, you cannot bring a block at a time. You cannot bring a pack of sand at a time. You have the materials on site. You spend VAT, which is what the ASP wants to make sure that you do spend that money. And once it is on site, whether it is actually part of a wall or whether it is actually part of construction is immaterial. This is my submission, my lord.
So you're saying that the hypothesis that's being put to you is an unrealistic one because of the way the construction industry operates?
Exactly, my lord.
Yes.
Yes. Just moving on what happened after the ASP. We had the amendment brought to the various pieces of legislation we're concerned with. First of all, the Income Tax Act and the Land Duties and Taxes Act were amended to implement the adjustments package. And I'm looking here, my lords, at sections 8 and 12. If your lordships will have a look at the list of authorities, tab 1.
Page. Oh, that's it. Sorry. Yes.
So we're looking at pages 400. So for Income Tax Act, it's page 415, which is section 8. And for the Land Duties and Taxes Act, it is page 418, section 11. So these were the amendments that were brought to those two laws. And we're here mostly concerned with the Income Tax Act. And a couple of observations I'd like to make here, my lord. First of all, the only taxes concerned here are registration duty and land transfer tax. Now, my lords, these are normally managed by the Registrar General under the Land Duties and Taxes Act. I refer lordships here to the additional list of authorities, which unfortunately was sent slightly belated to your lordships, at tab Roman numeral 2. At the index page, your lordships will see that parts 2 and 3 of that act concern registration duty and land transfer tax. And the reason I raise this point, my lords, is because we have noted that under the ASP, the authorities were specifically minded to give the MRA the responsibility of managing the fiscal measures under the construction industry. And the question then would be, why did the legislator give the Director General of the MRA and not the Registrar General responsibilities that normally befell the Registrar concerning those two types of duties? The point I'm making here is that the MRA is normally concerned with income tax and corporate tax. And the answer to my own question, if I may, is that the Registrar General did not have the requisite powers under the Land Duties and Taxes Act as it then was to enable it to perform the functions which the legislator wanted it to perform under ASP. And in support of my contention, I'd refer your lordships to tab 2 again at section 42. Which is found in the second page, where the powers of a Registrar General are really very, very limited as regard.
Sorry, which page is this?
The page is not numbered, my lord, but it is at tab Roman numeral 2. It's the second page.
Sorry, this is the other bundle. Yes, I see.
I'm in this is a smaller document.
Sorry. I hadn't got there. I do beg your pardon.
I'm sorry, my lord. It
That's
came
all
in
right.
late.
My fault. Yep, thank you. Yep, 42, yep.
Yes, Roman numeral 2.
Yes, I have it now, thank you.
Right. Your lordships will see again the references to parts 2 and 3 for recovery of duty. These were the only powers of a Registrar General. And your lordships will see that all the Registrar General could do to monitor, as it were, payment of taxes under the Land Duties and Taxes Act was to go to the judge in chambers and obtain an order of contrainte.
I'm sorry, what's your point here? I mean,
The point I'm making is that there was a reason why the MRA and not the Registrar General was given those powers. And the reason why this becomes important, my lord, is because when we look at the powers of the Director General of the MRA under the Income Tax Act, then we have to read those powers in line with what it had to do with a non-income tax or corporate tax situation,
yes,
which is what it normally does.
Does that help on the question?
It would help, my
whether
lord,
works
in...
have been completed or not?
I think it would help if when I come just after, to looking at the powers of Director General.
it comes in at all at your second stage, doesn't it?
It does, yeah. I'm basically laying the foundation, as it were.
For the decision-making process, which is your...
Exactly, my lord, yes.
Yes, okay.
Yes. I will also draw your lordship's attention to the fact that in more recent years, the powers we have just seen of a Registrar General have been substantially enlarged. The reason I say that is because it was probably found that it was not possible to monitor the payment of land duties, registration duties and land duties and taxes with the existing powers of Registrar General. And I refer your lordships here to tab 2. Again, your lordships see 42A, the next page.
Thank you.
This is an amendment that was made in 2015, my lord.
Yep.
And your lordships would also see a further amendment that was made in 2016,
Yep.
which appears in the next tab, Roman numeral 3.
Right. And what amendment do you want us to look at there? 42A, the new 42A.
Yes, and now I've moved on to Roman numeral 3,
Yeah.
which is the website of the Supreme Court is not yet in our revised laws. These are the more recent changes that have been made.
Are you looking at 42A again or 42 again or what?
No, I'm looking now, my lords, at 42B and C.
Thank you. Yes, on the last page.
Yes,
Thank you.
which gives us the again, the additional powers, the enlargement of the powers in recent years.
But these are more, don't affect the
They don't
case
affect
law.
us, no, they don't. But it's just basically to show that
Yes.
it was, let's say, unconventional situation where someone who should not have been managing that law was given the power and duty to do so.
Yes, okay.
So that comes to my next question, which is what then were the powers that the Director General of the MRA had under Section 161A, subsection 27 to 33?
Still going to your second point, is it still?
This relates to my second. No, that's actually. So I'm still talking about. I'm still about the Argentines package. I'm looking at. If your lordships will recall.
You're discussing the role of the MRA under your first topic, but you're then moving on to the decision-making process in this case.
Yes.
Exactly. No, we're still talking about the role of the MRA.
Yes.
On this first one. Thank you, my lord.
Yes, thank you. Yes.
So I come to the powers of a Director General. My answer to that question, my lord, would be that the ASP itself, the amendments to the Income Tax Act, did not actually introduce new powers. There are no new powers given to the Director General of the MRA. So that it was then left to the Director General to exercise the powers it already had under the MRA, under the Income Tax Act. And those powers, my lords, are found at Part 9 of the Income Tax Act. I refer your lordships to tab Roman numeral 1. On the index page, it's Part 9, sections 123 to 128A. And in my humble submission, my lords, the powers, if one analyzes the powers under Part 9, it is quite clear that most of the powers concern assessment to tax and powers in relation to making such assessments. However, I can identify two powers which would be directly relevant to the ASP, and those would be the provisions found at 123, which is the power to require information, and the provisions at 126, which would be the power of inspection. So how would the MRA then fulfill its statutory duties under the imported sections of the ITA? My humble submission, in the furtherance of the ASP measures, the involvement of a role of the MRA comes at several levels. They're broadly split between the pre-registration and post-registration duties. I refer your lordships to the list of authorities at tab 3.
Page 476, is it?
That's right. Thank you, my lord. 476. For the pre-registration requirements, which I humbly submit are of a mostly administrative nature, we have, first of all, the registration of a project under the ASP. That's section 161A, subsection 27. Registration of construction projects. And then we have ensuring compliance with pre-registration requirements, and those requirements are found at subsection 28, subsection A and C. So A would be that the company is a company incorporated or registered under the Companies Act, and C would be that the company submits at the time of registration a number of things, And this is very important, my lord. The list of 6 items which needs to be disclosed prior to registration. This is also monitored by the MRA. And the second pre-registration requirement, my lord, is at subsection 31, which is issuing the certificate with or without conditions. I would also hasten to add that the conditions, and my friends have agreed on this, that whatever conditions would be imposed would be conditions within the 4 corners of the law itself.
We say the conditions were within the 4.
So these are the pre-registration requirements, which to my mind are mostly of an administrative nature. But the more interesting ones are the post-registration requirements, which here entail consideration of technical information. And I'm referring here, my lords, to section 28B, which is the critical section, where the total costs of construction of the buildings under the project exceed 50 million rupees by the 30th of June 2011.
Yes.
And subsection 32.
Yes. Purpose of monitoring.
For the monitoring.
Yep.
Now, for those 2 subsections, it is quite clear that the monitoring of the costs of construction would entail the applicant to submit a quantity surveyor's report under subsection 32,
Yes.
subsection B. And also, my lord, there is also subsection 29,
Yes.
which is another post-registration requirement, which concerns the determination of whether works effected are of a nature of ancillary infrastructure works,
Yes.
which would require obtaining technical information pertaining to the nature of works effected in a construction site.
If goods had been delivered, building material had been delivered to construct walls, drains, or roads, and was on the site and paid for, could that be taken into account on your case?
Certainly not, my lord.
No.
There is a clear exclusion. And this is where the MRA's powers were required to be exercised judiciously, knowing that there is an exclusion concerning drains, walls, and...
So if you just had bricks which were needed for walls and for the building, and you didn't know which, and they were the same bricks, how would you decide?
I'm sorry, my lord?
If you had bricks delivered to the site which
Yes.
were going to be used possibly for walls or possibly for the buildings on the site, how would you decide which they were going to be used for on your case?
Only one way, my lord, is with the support of technical information. In other words, you would
But if
require...
they could be used for both.
Let's suppose that they had a huge pile of bricks and they were going to use them indiscriminately for the building of the qualifying works and for the drains and roads, etc.
Right.
And there was no decision made until they needed to use them.
I thank your lordship. This is precisely the point of the appellant, that it is not up to us as lawyers, or even for the MRA as a regulatory authority, to make those judgment calls. It is only up to the quantity surveyor, because this is a technical matter.
What?
We will not know.
Hang on a minute. It's not just a matter of monitoring. Section 28B
Yes.
and 29 are relevant to what the company submits to the Director General in order to get registered in the first place. So the plan, the business plan in C4, has to have costs of construction of the buildings under the project exceeding 50 million rupees by the specified date.
Yes.
And those costs have to exclude all the ancillary infrastructure works in subsection 29. So the quantity surveyor instructed by the applicant for registration would know at the outset what was in and what was out in what he presented.
Absolutely, my lord. And perhaps I don't want to jump around, but it might help your lordships in support of this particular point, to have a look at the terms of reference of a quantity surveyor. If I may refer your lordships to Mr. Murugan's contract.
Basically, the function that the quantity surveyor has got to carry out is defined by the Act, isn't
Yes.
it? So, in this case, the quantity surveyor has got to report on the progress of the works and the cost of construction works completed. Now, if we were to interpret construction works completed as meaning something that's actually been built, then it follows that the quantity surveyor has got to report on that. The quantity surveyor can't have a discretion to decide what he's going to certify.
Yes, I follow your lordship, but then the interpretation your lordship puts on completed is not the interpretation that a quantity surveyor would put on the same term.
But it's a matter for the courts to decide what that statute means, isn't it? Not the quantity surveyor.
Based on the quantity surveyor's report.
With respect, the quantity surveyor's report apparently complies with normal practice for seeking interim payments. But normal practice for seeking interim payments would include seeking interim payments on ancillary infrastructure works. So that the task that the quantity surveyor was set pre-registration, in preparing the pre-registration report, was different from that which he would normally carry out under a private sector building contract. So from day one, his task was different.
Yes, 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 my lord. I just would like to point out, your lordship, that in the quantity surveyor's own appointment, he was specifically appointed to deliver a certificate. The point I'm making here is that he was aware of the terms of the ASP.
But how can the instructions to the quantity surveyor affect our interpretation of this statute?
The point on this, my lord, is that it is only with the support of a quantity surveyor's finding, technical finding, that either the MRA or the court can make a determination of fact. Because it is not within the layman's knowledge to ascertain what would constitute a phase of construction, what would be the significance of the materials on site, what would they be used for? Would certain dimensions of iron bars, for example, be used for fencing? Or this is something we have no expertise on. And this is why the legislator, I may humbly submit, took the precaution of inserting the fact that there should be a quantity surveyor's report, specifically to remove from the Director General of the MRA that supposed discretion to make a finding which might be totally wrong.
But there's no dispute about the facts here. There's no dispute that the building materials had been delivered to the site but not incorporated in any building.
There doesn't seem to be any dispute, my lord. Nothing has come up in the course of this case.
So it's a pure question of what construction works completed means. That's the only question.
As a quantity surveyor would understand it, yes, my lord.
Why would understand it?
The quantity surveyor would understand completed as being begun, my lord. This is my submission. Because, I'll just fast forward on the submissions I would be making later, but since the question has come up, I'll address them now. If your lordship will look at the sequence of events, the certificate was given in November 2010, 1 month before the end of the period, the ASP period.
Ought we to look at it at some stage, Mrs. Boulel?
The certificate?
Yes.
Yes, my lord.
Is it at 16?
Yes, my lord. Thank you, my lord. It's page 16 of the record.
Page 16, did you say?
Yes, my lord, of the record.
And are the conditions set out at the bottom?
Yes, my lord. There are what we term conditions. I would simply say that they repeat what the law says. But the date is important. It was issued in November 2010, 1 month. 1 month and a bit before the end of the ASP period. Now, the construction works started, my lords, and this is on record. Just fast forward in my other notes.
The only date we've got for that is mid-April, I think, Mrs. Bula.
That's right. I'm just trying to find what it is in the brief, but you're right, my lord. It's mid-April. JCPC. That's right. It's, my lord's page 84 of the brief, of record.
84.
Yes, my lord. This is a note from the financial consultant of the applicant informing the MRA that foundation works are scheduled to start mid-April 2011, and a progress report will be sent to you as per the requirements of the certificate. And, my lords, the period for the monitoring ends 30th of June 2011. Now, it cannot be suggested at any point in time that in the period between April and June, there would be any constructions completed. And this is precisely the point I'm trying to make. There would certainly be construction works which would have begun, yes. There would certainly have been construction works which would have been begun, but there would be nothing completed. Unless we're saying that digging of trenches or putting a few blocks to start a project would actually amount to anything completed. Now, the reason this is all the more material is because the termination date for the construction was not only meant to be before 2013. And I have this, my lords.
But that was a risk, wasn't it, that your clients took?
A very calculated one, I hasten to add.
If they start late in the exemption periods, then they're going to have to work that much faster and take a larger risk of failing to meet the deadline.
I wouldn't subscribe to your lordship's view to the extent that the risk here was a financial risk, calculated financial risk to spend 50 million by, at least 15 million by the 30th of June.
Yes, and the question simply is, was that 50 million to be spent on actual construction works, or was it to be spent on construction works plus putting materials on site?
Yes, my lord.
So that your client took a risk and got quite close to the 50 million as regards the construction works,
yes.
But to meet the threshold,
yes.
It had to submit that the materials were included in the package.
Yes.
Yes.
And this is the practice adopted by any quantity surveyor.
But that depends on the purpose. And obviously it's a practice adopted by any quantity surveyor if he is certifying the value of performance under a building contract to date for the purposes of an interim payment. But it's not his proper function if he is certifying something different, namely whether construction works have been completed.
I would submit on this, my lord, that the MRA was perfectly alive to the fact that it was meant to monitor a progress of works and construction of in a situation which it was not normally called upon to act. Since it had those monitoring powers, it was up to the MRA to issue clear directives from day one to say, all right, we're not in a normal building situation here, and this is not an interim payment, so don't come and claim for materials on site because you will not be exempted from those.
Well, but clearly, this is the point I was making to you earlier, if you read subsection 28B and subsection 29 from the outset of the project, from the initial certification, it was quite apparent that you were not in a normal situation because, apart from anything else, all ancillary works had to be excluded from the business plan for the purposes of monitoring entitlement to the tax advantage.
And quite rightly, my lord, the only exclusion which anyone applying for the exemption at the time would be aware of is just those listed at subsection 29 for ancillary infrastructure work. There is no other exclusion. So if I am to act on the representation made to me by the state, as replicated in the ITA, I can only act on what I see. I cannot act on something that is not communicated to me, or communicated to me ex post facto, which is what we have here.
Well, I wonder about that because it's the point that my colleagues have already put to you. How do you distinguish between materials on site which are for the building and materials on site which are for ancillary work? I mean, the quantity surveyor, one might say, was on notice
Yes.
that he or she was carrying out an unusual exercise.
Yes, my lord. I would like to clear this point which I was looking for earlier. If I just may be given a couple of minutes to look at the... if I refer your lordships to page 117 of the record,
Yep.
we have the completion date here, which is 31st December 2013. But more importantly, my lord,
Where do we see? Oh, yes, I see.
it is said here in the first bullet point,
Yes.
the schedule of payment of fees. That is the actual fee proposal made by the quantity surveyor, and this is the description of the project.
And the date of this is March 2011.
Yes, my lord. That was when I suppose, when the quantity surveyor was retained.
But someone would, I mean, in order to get certified, in order to get registered, you would have had to put in a business plan including...
Oh, yes. Oh, yes.
And that was, I mean, what did that, do we have that?
That would have exactly the same thing, my lord. We don't have the documents, but this is the date. The completion date of a project was always meant to be.
But except, to get registered, the whole point was you needed to be able to show that you were going to complete 50 million rupees work by the 30th of June 2011.
Yes, my lord.
So presumably there was some sort of business plan under Section 28 which would have shown that.
Yes, the
You've
business
not,
plan.
but where is it?
We don't know. It is obviously with the MRA.
But because it seemed to be very odd if you submit a business plan under Section 28, which shows completion in December 2013, when it's quite clear that what's required under the Act is something to be completed by the 30th of June 2011.
Well, it may be, I suppose, that the project was worth much more than 50 million, and that
That's possible.
The project...
the completion referred to completion of the entire project rather than completion of the 50 million.
Yes, of course.
If I may venture, it's not in the record, but the project was worth 770-odd million
I see.
rupees.
770 million.
770 million.
Because it was a large
project.
of apartments.
May I also, apartments, may I also...
So it was realistic, viewed as at
Yes,
March 2011, that 50
absolutely,
million...
my lord.
Well, you say absolutely. You haven't answered my question. Was it realistic that $50 million of actual work would be done before the June 2011 date?
This was represented by my client, my
But
lord.
yes.
Anyway, we have the date. Yes.
There we are. Yeah, thank you.
And the next page, my lord, is what I thought was opposite here. It is at page 1, at note 1.3.5, at page 119 of the record. But part of the services to be provided by the quantity surveyor was to prepare a QS certificate of a total cost of construction for works executed as at 30th of June 2011. And at the next page as well, page 120, note 1.3.7, to prepare a quantity surveyor's report every 6 months certifying the progress of works and the cost of construction works completed.
Okay. And so what?
The point making here is that the quantity surveyor, when he drew up his report and all his subsequent reports for this project, was totally aware that there was this law in place, that this project had been registered under the scheme and that he was required to comply with whatever the law said.
Yeah, so what? Doesn't mean he necessarily did comply. The fact that he thought he had doesn't mean he did.
I humbly submit, my lord, that there is no evidence to suggest that he did not.
Well, there is, because if you're wrong on the construction of the Act, then he included material which was on site, but not the subject of construction work, or hadn't been included in a building. So if you're wrong on the point of law here,
Yes.
he was wrong too.
If you were to look at it from this point of view, yes, my lord, yes. May I also, since we were talking about completion of a project, I don't know if I may add, it is a project that's actually completed. It is a very ambitious project, which is, judges in Mauritius would take judicial notice of it because it's in a very busy urban area. It's a 4-block apartment, and it is completed within the time frame that has been imparted here.
Yeah, I mean, I see how you can say that if the decision is right, you've been disadvantaged by what some people might say was little more than a technical failure on the way. But nonetheless, the law is full of technical problems for people which the courts have to give effect to.
Yes, my lord. If I may just go back, my lord, to where I was on the pre-registration and post-registration requirements.
I mean, obviously you have spotted that at 119, on behalf of your company, Huluman are telling the quantity surveyor that part of his job would be to prepare a certificate for the construction for works executed.
Yes, my lord.
Yes, very well.
So we come then to the next question as to what is the nature of a power of a Director General of the MRA that he was called to exercise in performing its statutory duties under subsection 27 to 23. Humble submission, the legislator was alive to the fact that the Director General of the MRA would be required to perform duties not normally concerned with the management of revenue laws, especially as regards the monitoring of post-registration conditions. It expressly provided that the Director General of the MRA would be guided by a quantity survey report, the quantity survey of the applicant, which would certify the progress of works and the costs of construction works. These are the terms used at subsection 28B. In my humble submission, this might help to conclude that the legislator did not intend the Director General of the MRA to exercise any discretion in the matter of ascertaining the costs of construction works. Going on the basis of its existing statutory powers under the Income Tax Act, it is being submitted on behalf of the appellant. But the Director General of the MRA would be able to question the report of a QS, inspect the construction site, and even the valuation of a construction works submitted by the applicant's QS with a counter-valuation report of its own. Since the MRA itself had no such powers, and the reason I say so, my lord, is your lordship should have a look at tab Roman numeral 4 in the smaller list of authorities. Section 3. It's headed part 2, the authority. We there see, my lords, what are the resources available within the MRA. Lordships will have a look at section 3, subsection 4. The authority shall comprise the Office of a Director General, the Customs Department, and one of the tax departments, subject to subsection 5b, the Fiscal Investigations Department, the Legal Services Department, and such other departments as may be set up by the board, and the Internal Affairs Division and the Internal Audit Division. We are not aware as to whether, in our particular case, the MRA actually set up a special department to monitor works as per the ESP. But judging from the resources available under section 3, subsection 4, clearly the MRA had no expertise in-house as regards construction matters. If I may now move on, my lords, to the second point I wanted to raise, which was the decision-making process adopted by the MRA. We have seen, my lord, that the MRA is a statutory body set up under section 3, subsection 1 of the MRA Act. I refer lordships to tab...
You're taking us to this for what purpose?
To show how the MRA is supposed to be exercising its powers, my lord, leading to...
Is this for the purpose of saying that they should have, were required to accept the certificate, whatever, or is it for some other purpose? Sorry.
No, I will take your lordships briefly through the main sequence of events.
Yes, I'm trying to understand why we're being taken to the powers of the MRA.
The reason being that...
What issue does it go to in this case? That's what I'm getting at.
The point I'm trying to make here, my lord, is that the decision-making process itself was flawed as to how the MRA conducted itself to reach...
Under all these heads, your complaint is essentially that they didn't ask you for clarification
Yes.
of your position.
Yes.
Now, on what point should they have asked for clarification?
I would have submit, my lord, that perhaps it might be simplistic for me just to say that they should ask for clarification. I think it's perhaps...
Well, I mean, if you're saying that they should have asked for clarification, you must have a submission about what clarification
Yes. Yes.
they should have asked for.
Or what you would have said if
Yes.
they'd asked for clarification.
I think the clarification that could have been asked, there are several things that could have been done. Let's start with this. That clarification is one thing. But on the issue of clarification, if the question had come as to why have you included building materials on site in the cost of construction, an explanation would have been forthcoming from the quantity surveyor of the applicant.
Can you tell us what further facts you would have provided to the MRA if they'd asked the questions you would have said they should have asked?
First of all, my lord, I would be able, my client would have been able to show that certainly none of the items under subsection 29 were involved in the materials on site. That's one thing.
Yes.
Which was important.
Okay. Well, I'm not suggesting that they were. I was just working out.
In the realm of systemizing.
What would you have said to assist your case that you haven't been able to say? Or what would you have added to the certificate? What facts would you have added?
If I may just go to the decision itself, and then I would actually refer to what would have been the response of the appellant at that time. The decision, my lord, is at page 85 of record.
85?
85, my lord. I'm so sorry. It's, no, I'm so sorry. It's,
That's a certificate.
Yes, I'm so sorry.
That's a covering, that's a covering letter, and then the certificate's on the following
Yes.
pages, and we see the materials on site on page 87, paragraph 9.
Page 20.
20.
20, yes.
20.
I'm sorry, my lord.
Sorry. Page 20, right.
Second paragraph.
Yes?
The decision.
Yes.
We regret to inform you that the value of materials on site
Yes.
cannot be included in the total cost of construction at 30th of June. This is the decision, my lord.
Yes.
So answering your question, the question of your lordship, what could I have done to better express myself?
No.
First,
Yes.
well, put across my case. Okay. First of all, I would say that, please, can you come and check what those materials are? Because you have this power. They are on site. Alternatively, my quantity...
Your point is that the certificate tells us that.
Yes, and if it's not contested, then we agree that these are the materials, and these materials would not be used for anything under ancillary infrastructural works. So the next question then is that they should be included in the cost of construction, because this is the way it is always done.
But that's ultimately a legal issue.
Yes.
That would end up being a legal issue.
It's a legal issue, and asking your clients what the answer is wouldn't advance matters, and saying this is because that is how it's always done is simply a reflection of what is done in the private sector for interim payments.
Yes. And I don't know if it's the right time for me to refer to lordships to practice.
If we conclude that the statute means that the building work has actually got to be done, it's not good enough to have materials on site, if that's the law, then frankly there's nothing that you could have said in response to this, given that it's common ground that if you don't take into account the value of materials, you didn't hit the 50 million target.
I agree, my lord, because of the way the decision is taken and the way it is framed.
Oh, no,
I would however submit...
The way the law is, that's the reason why that would be the result.
Yes.
But the statute, if that's what the statute means, there's absolutely nothing you could have said in answer to this.
Yes, my lord, but I would still say, at the risk of perhaps being totally wrong, but I would still submit that the MRA, immaterial of whatever interpretation could be made of Section 28B or 32B, it still had a duty to act fairly. It did.
But yes, but where is the unfairness if your answer could not affect the outcome?
My lords, the unfairness is in the fact that the decision was taken in a manner that didn't allow the appellant to explain.
Yes,
that...
but if the explanation wouldn't assist,
yes,
because it's simply a legal issue, where is the unfairness?
I would suggest that the unfairness is in the brutality in which, in a totally non-consensual manner.
I mean, there are only two issues which in this case, the MRA had to be concerned with. One was, did the 50 million did you only reach the 50 million because you included materials on site? That's a question of fact, and you agree that the answer to that question is no, and that's always been the position. Question two is that good enough as a matter of law? And that's what we're arguing about now. But arguing about it before the MRA wouldn't have helped anybody.
I think the answer to the first question is yes. You only reached the 50 million because of the materials. Yes.
I still venture to say, perhaps again, at the risk of being totally wrong, that is a clash of titans. It's not a level playing field here.
Can I just ask this? On page 93,
yes, my lord,
we see the affirmation of director of your client
yes,
in the Supreme Court. And he sets out at paragraphs C and D
yes,
and E what I suspect would have been what he would have said to the Mauritius authority.
which he's been saying all along, my lord.
Yeah, yes, he's being completely consistent, and it's consistent with what you're saying now.
Yes.
But whether or...
split.
Yes, I mean, but the fact of the matter is he's said it.
He has.
In court, he said it to us, you're saying it to us. So the issue is really whether that's good enough in law, and so any unfairness in not enabling him to say it loudly and clearly at an early stage really has been overtaken by events, hasn't it?
I take your point, my lord. I take your point. So moving on then, if I may, on the MRA and its powers, I think it takes me very nicely to the MRA Act itself and the duties of a Director General under the Act. I refer your lordships to tab Roman numeral 4. And I refer your lordships to section 4, functions of the authority. And I read there, section 4, subsection 1b. The function of the authority shall be to monitor, oversee and coordinate all activities relating to and ensure a fair, efficient and effective administration and operation of revenue laws. C, deliver a high standard of service to the public with a view to promoting voluntary compliance with the revenue laws, promoting fairness and transparency, increasing the efficiency and effectiveness of its departments and divisions, and maximizing revenue collection. For the sake of total completeness, I refer your lordships to Schedule 1, which includes the Income Tax Act as a revenue law. In fact, Schedule 1 as the Income Tax Act, the Mauritius Revenue Authority Act, and the Registration Duty Act.
Yes.
And just to complete the picture of what is the trend in terms of how the MRA is viewed in terms of the exercise of its powers, I refer your lordships to section 7, capital A.
Yes.
Which is
Yes,
an
yes.
amendment that was brought in 2015. It doesn't really concern us directly, but it's indicative of the manner in which the MRA is seen to be exercising its powers.
Thank you.
That wherever there are discretionary powers, under any revenue law, he shall, in such cases as may be prescribed, issue statements of practice. Yes, thank you, my lord.
But are you saying that the decision that the authority had to make was a discretionary decision?
The decision was a discretionary one.
How?
Because it only had the report of the quantity severe before it and nothing else.
So that brings one back to the two issues that I identified a few minutes ago, neither of which is discretionary. One is a pure question of fact. Do you or do you not hit the 50 million without taking into account building materials on site? And the other is a question of law. What do you need to show? And neither of those are discretionary, and there's nothing else that the MRA had to decide.
In my humble submission, my lord, when you have a report of a quantity severe, the MRA, again, as I said, has no expertise to dissect that report and to read into it.
Need it, because everybody agrees that the relevant fact was that you didn't hit the 50 million unless the materials on site were legally relevant.
Yes, again, the discretion, even the question of fact, should have been decided by the quantity severe, not by the MRA.
But that he did decide it. He said that 11 million, 10 million of the amount was materials on site, and we all agree that that's right, and the MRA agreed it was right, but they said it wasn't good enough in law.
Wouldn't then be the bailiff entitled to say, well, who are you, MRA, to decide this, when you just look at a report?
Well, there's nothing in the report. I mean, let test it this way. Let us say that the quantity severe made it clear that in order to reach the 50 million level, he in respect of one site, he was including construction works carried out on another site, a clear error of law. Would the MRA have to defer to the quantity severe's expertise in that regard?
I think it would be prudent and fair for the MRA, before taking a decision, to actually verify whether...
Let's assume the facts are correct.
Yes.
Let us assume that the quantity severe included construction works on two sites to reach the 50 million level on one side, a clear error of law. Couldn't the MRA then say, you've got it wrong in law?
Based on what? On the figures of the quantity surveyor?
Well, based on the agreed fact that he was relying on two projects, the work on two projects to reach a limit on one.
I suppose if on the face of a report it showed that there were two projects and there was a clear breakdown of what each project component cost was, that would be a question of fact, yes. But if it was just a question of identifying from a total figure which would impute two projects, which was from what project, I think then a quantity surveyor's report would be required.
But why is it any different here, where it is agreed between the parties that in order to reach the 50 million rupee limit in respect of this project, you have to include the material costs on site?
It's not stated anywhere, my lord. It's not stated anywhere that construction materials should or should not form part.
But that is a question of legal interpretation.
If I may, my lord. I just referred earlier to the sequence of events leading up to the construction. I don't know whether your lordship still want to hear me on the question as to whether the MRA acted in line with the statutory functions in view of the comments that have been made.
Well, I'm not sure it will be very helpful. Perhaps you could summarise your submission.
Yes.
Briefly on that.
Yes.
So make sure we have it.
The point, I think, the main point here is that there was a very questionable decision-making process adopted by the MRA.
And I think the point that's being made to you is, even assuming that's right, and I'm sure it'll be argued against you by Mr. Baker that it isn't, but let's assume it's right. I think our problem is seeing, to put it bluntly, if there was some failure, so what? How did it in any way prejudice your client? And I think we see that.
I hear, Lordship.
We see that as being the insurmountable problem at the moment.
I hear, Lordship. May I just raise one point?
Yes, of course.
Hopefully to sway Lordships into thinking my way. But
It's your job.
there was also the piecemeal exclusion of other items, other than construction material on site. Now, the letter, the decision, only had one item. Construction material on site cannot be included in construction cost. That was on the 16th of September, 2011, page 20 of the record. And then, on the 9th of January, 2012, another item is added. Metal hoarding. I refer your lordships to page 97, paragraph 5A of a record.
5A.
Yes, my lord.
Yep.
For the first time, the MRA says the value of the amount of materials on site in the sum of 10 million odd and the value of metal hoarding around site, which is not an excluded item under subsection 29, to the sum of 656,000 odd rupees. That comes in for the first time.
Well, this is an affidavit sworn after the relevant,
Yes, my lord, after the decision.
After the relevant decision.
Yes. And again,
Whether they were right or wrong about that, 10 million worth of materials on site was enough
Yes.
to push you on the wrong side of the 50 million target.
that was the argument brought forward earlier, but I would, if I just could finish the third item and show your lordships that there is a reverse argument to this. On the 1st of July, 2013, again, another item is excluded.
Page.
Page 81, my lord.
I mean, materials on site is enough to, if they're right on that, that's the end of the story.
Arithmetically, yes.
So so what about these other matters?
Here, we're looking at a situation where, right at the time when the decision is taken, there's no clarity in terms of what should or should not form part of the construction works. This is the point being made. If the MRA was clear, as at the 16th of September, that those items were all to be excluded, it should have said so.
Well, yes, but let's say, therefore, let's assume in your favour
Yes.
that therefore we forget those items.
Yes.
The revenue can't rely on them.
Yes.
So what? You still fail because of the 10 million, unfortunately.
I hear, Your Lordship, but the only point I'm trying to make here is that if you added only those two other items, that is, the metal hoarding and the external works, it would still be within the threshold. So the point being made here by the MRA is, okay, you're outside 10 million anyway, so it doesn't matter how many other items we deduct because you haven't met the 50 million threshold. That's fine. But again, if instead of saying construction material on site in that first letter, you had mentioned those other two items instead, I would be within the threshold. So is that fair? That's the question I ask myself. And perhaps I'll move on, because I know that your lordships don't want to hear too much about this. I'll move on to the next point.
Could you go back a moment to the discussion about whether there's a discretion?
Yes, my lord.
Because we haven't, I think, looked at the provision of the Land Duties and Taxes Act, which tells the director what he's got to do. This is at page 4, 9, 4 and 5. It's section 45, big A of that act, I think, which deals with derogation.
Yes, my lord.
And subsection 5 deals with the sort of things we're talking about. And it provides for the exemption.
Yes.
But the key provision, isn't it, is subsection 7, which deals with the position where the Registrar General is notified that the company has failed to satisfy the condition.
Yes.
And then he shall, by written notice sent, claim the duty and tax exempted, together with a penalty, and so on. So there's a duty to, once there's a notification, and that comes from the director, I think.
The MRA.
495.
Then there's a duty to claim the tax back. I mean, there's no discretion there.
There's not from the Registrar General.
No, but I
It's
mean,
from the MRA.
where do you get the discretion from then?
Under the Income Tax Act itself, my lord, the existing powers of the Director General under the Income Tax Act. The point I was trying to make is precisely that all that the Registrar General does, or is called upon to do, is to be notified. In fact, there's no active involvement of the...
Yes, but I mean, under section 32, I mean, doesn't the, yes, the 33 it is, the director, this is on page 478, the Director General shall, notwithstanding section 1, 5 and 4, give written notice to the Registrar General that the company has satisfied or has failed to satisfy the condition.
Yes.
So there's a duty on the Director General to notify the Registrar General, and section 154 is about secrecy that come into it.
Yes.
And then there's a duty on the Registrar General to get the money back. There's no discretion there, is there?
No, I don't read a discretion.
I mean, it seems to be rather draconian, because you might have been held up by weather conditions or something perfectly bona fide, and you suddenly find yourself paying a penalty. But that seems to be the scheme of the thing.
It's totally, in fact, the affidavits of the appellants throughout do complain about the fact that there is just a sort of duty to just comply.
I mean, there might be some reason for some sort of extra statutory concession, but as far as the statute is concerned, it's very clear, isn't it?
It is quite clear, yes. So let's move on then to the cost of construction, the meaning of cost of construction.
Yes.
She's only got 10 minutes.
The term...
I appreciate you've
Yes.
only got...
Am I running out of my time?
No, you're not. You're not. I'm just, in fairness to you, I think you've got about 12, 13 minutes more. But that's fine. But
I don't expect to be more than about 15 minutes, my lord.
in that case, carry on.
Thank you
Sorry
very
I
much.
interrupted you.
Unless your lordship would like to break now?
No, I think it's sensible for you to deal with what may well be the essential point in the case.
Thank you, my lord. So coming to the meaning of costs of construction. The term that was used in the additional stimulus package, my Lord, was construction works completed. I refer your Lordships to tab 24 in the list of authorities. In the document itself, the ASP document. And that was the extract we looked at earlier at page 797. The term used is 50 million rupees of construction works are completed, at least. The term imported within the Income Tax Act, I refer here to tab 3. Is, first of all, at subsection 28B, page 478, the total costs of construction of buildings under the project. At page 478 again, subsection 28C4, which talks about the other conditions, pre-registration conditions that need to be satisfied. The term used there is estimated total costs of construction and estimated costs of work.
Well, that's all you can say at the outset, isn't it? Nothing's been done yet. You're saying what you're going to spend on construction.
Yes.
Then
yes.
the question arises when the deadline comes up.
The point I'm trying to make again is what was really in the mind of the legislator was satisfying expenditure. It's making sure that those costs were incurred, quite apart from how much work was completed. And perhaps I'll come again to subsection 29, which is the exclusion clause, which again talks about costs of ancillary infrastructure work. The only place, my lords, where the term completed appears is in the monitoring section, which is at subsection 32.
Yes.
Subsection B. Completed doesn't appear anywhere else. Now, there is, again, and in that same subsection, it's monitoring the costs of construction.
Yes, it's interesting, isn't it, that the heading is monitoring costs of construction.
Yes. There is no definition, my lords, of a term costs in the Income Tax Act. And the term costs, in my humble submission, is the term that is really overwhelmingly repeated throughout this amendment. And I would here depart.
What?
Well, I'm just pointing this out because the submissions for counsel of the respondents in the lower courts, and even the respondents in the written case, has been that the material word is completed. And then perhaps I refer your lordships to the sitting of the 23rd of June at page 228.
The submission below.
Yeah. Well,
Submissions were made along those lines, my lord. Page 228.
Well, that is indeed also the submission that is being made against you on this appeal.
yes, don't worry about
So it doesn't really matter what was said below. I mean, the question really is, what does it have to be the costs of? And the answer appears to be, it has to be the costs of construction works completed, C32B.
But even if it's 28B, the costs of construction, does, as a natural, ordinary meaning of the word, does that extend to materials on site, which are simply, as it were, dumped on site and paid for? Possibly not paid for, but anyway, on site. Is that part of the construction?
I would happily submit that the way we understand as lay people construction works is not necessarily the same way a quantity surveyor would understand it.
No, but this is a question of interpreting the statute.
Yes, yes. Again, my submission would be that materials on site to be used as part of a construction I used an analogy before the trial court that, you have a cloth, you can't just take the sleeve out and say this is just part of a garment. There is an element of integrality that goes in the way the construction work happened. And we as, let's say that there are technical people who know how to assess those. And we have to sometimes defer to their knowledge as to what their practice is, what their norms are, and what guidance they have from their own industry practices to come to those conclusions.
And, 28B
Yes.
is concerned with registration.
Yes, my lord.
Predicted expenditure.
That's predicted expenditure, isn't it?
I'm sorry, my lord?
That's predicted expenditure, 28B.
No, my interpretation is that this is a post-registration requirement.
How can it be? Because
Look at the opening words of 28.
At the time of registration, you've got to submit this information.
You wouldn't have this information at the time.
Well, exactly.
But it's predicted in 28, you're right.
it has to be predicted.
Yes, my lord, it is
So-
predicted in C4.
Yes. So it's all estimated. So that doesn't really help. It doesn't mean that you have to cut down the expression in 32B. It's dealing with a different thing, technically.
The case for the appellant is that he has actually lived to his promise, and whatever he has represented before the MRA at the time he complied with C4 is exactly what he has done.
Yes, okay. So your point is, first of all, this is how it would be understood by a quantity surveyor, and given that it's a quantity surveyor who has to do the certifying under 32B, that's a fundamental point. Yes?
That is a fundamental?
Your point is it's fundamental that it's how it would be understood by a quantity surveyor because it's a quantity surveyor who's got to produce the report.
Yes, my lord.
Secondly, we shouldn't give too much meaning to the word completed because if you go back to 28B, it talks about costs of construction,
Yes, my
not
lord.
costs of construction completed. Okay, we have those 2 points. What other points?
I would just quickly draw your lordship's attention to the words used by the Supreme Court, which would perhaps lend, in my humble submission, maybe slightly misleading. And I come here, my lords, to page 281
Thank you.
of the record. Where their lordships import terms which are actually not in the law. The word actually being buildings, I refer here, lordships, to lines 24, line 24. The cost of construction work shall include the cost of construction of the buildings which had actually been completed. This is totally anomalous when you read the rest of the Act.
Well, it's true that if that means that the buildings have to be completed as opposed to that 50 million worth of construction works have to be done,
Yes.
that may be inaccurate, but I mean it's pretty obvious from the tenor of the whole judgment what they thought the problem was.
Yeah, well, except, my lord, that if it were the finding of the Supreme Court that this was the right interpretation, I humbly submit that this was not actually explained by the Supreme Court. It was just assumed.
Yeah, but in the end, as with points of construction generally, interpretation generally, while of course one pays respect to the decision and reasoning of the court below, we're really looking at it for ourselves and
Yes.
deciding what it means.
Yes, my lord.
And I'm anxious that we have your arguments.
Yes, thank you, my lord.
And they are, as I say, the 2 arguments I've tried to summarize. But there may be other points, and I want to make sure that we have them on board.
Yes, in particular, Mrs. Boulel, I'm worried for you. Your time has almost run out. But you did want to say something about the delay.
Yes, my lord. May I be allowed to... May I just get some guidance from your lordships? Am I out of... Should I just wrap up?
No. The important thing is that you, while we don't like people to overrun, you have had quite a few questions, and the important thing is that you make all your points. But I think make them fairly economically.
I would be guided by your lordship. may I go on this issue of delay, if your Lordship wants me to address
I think
this?
you're right, you have emphasised it, and Lord
Yes.
is quite right, you should have
Yes.
the opportunity to.
The way I look at this point, my Lords, is that the question I ask myself is, what could have been the possible implications of a time lapse between the final hearing of a case and the date of judgment on the findings of the Supreme Court? I'm not for one moment suggesting, my Lords, that the judgment should fall simply because it was delivered 16 months after the last hearing. But I am suggesting that in that 16-month period,
Yes.
everything seems to indicate that their lordships may have lost focus of a number of matters that were put to them and which were not addressed.
If these matters are important to your case, then you should tell us what they
Yes,
are,
ma'am.
because
So
clearly
first of
we
all,
can put that right,
yes,
if they are valid points, by us dealing with them. So what are the points?
yes, the first point. The first point, my Lord, was the reference to the FIDIC contract and the applicability of paragraphs 14.3e and 14.5 of FIDIC rules. I refer, your Lordships, to the submissions made by the appellant at page 167 to 169 of the record.
What's FIDIC stand for, actually, Mrs.
I
Boulel?
think,
Fédération internationale des ingénieurs conseils.
Mrs. Boulel? I'm sorry.
I have it
What does it
here, my
stand
Lord.
for?
I have it here. I'll give you the exact word. Page 121.
Thank you.
Okay. Do you want to look at 167?
It defines...
What's your point?
I'm trying to look at the word FIDIC.
No, don't worry. Go
Okay.
to 167. We'll find it.
Anyway, the FIDIC contract is at page 121 of the record.
Okay.
I'm referring, my Lords, to submissions made at page 167 to 169 in the record.
These aren't submissions, are
I'm
they?
sorry.
These are terms of contract.
Yes, I've got it. It's 282, my Lord.
Thank you.
282. Paragraphs, sorry, lines 9,
Which page again, sorry?
page 282,
Thank you.
lines 3 to 9, my Lords.
Yes.
Now, this is a judgment, and
What's your concern?
the point here, my Lord, is that there were important submissions made to their lordships about the relevance of particular industry practices in the manner in which construction costs
Can
are
can you take us to those?
Yes.
I mean, they're dealt with in the next paragraph. The FIDIC practice is dealt with.
That's right. It comes to the next one as well.
What they're saying here is that the FIDIC practice is irrelevant because it's a question of interpretation of the statute. I mean, that is dealing with your point, admittedly in a manner unsatisfactory to your clients, but it's certainly dealing with it.
Yes. But they also say that they actually discard it altogether to say that, look, the law has to be interpreted as it stands.
Yes.
But that's what's being said against you here. And if you think there's something in the FIDIC guidelines which goes against that, you would no doubt have told us.
But the point I'm making here is that there were submissions made and a lot of substantial case laws put before their lordships on this point.
But you've been able to put any such case law to us in your printed case.
It is, they are there as well, my lords. They are
We
the case.
assume you put all the points you think are helpful to you, right?
They are there, my lords. The
So
submissions.
really, although it may be very unsatisfactory the Supreme Court took so long to deal with them,
Yes.
you're not prejudiced as far as your case in this court is concerned.
This is paragraph 56 of your submissions, is it? Page 16 of your submissions. The Tony Cox Dismanthers Limited.
May I know which page your lordship's looking at?
Page 16 of your submission. Sorry, I haven't got the... It would be, I think it's page 362, probably.
362.
I mean, this is the same point that you made to us directly earlier this morning,
361.
when you said that the it's got to be interpreted in accordance with the practice of quantity surveyors.
Yes.
And all that your present submission adds to that is that the Supreme Court does not seem to have been impressed by that, or at least dealt with it rather cursorily.
Yes.
And you rely on the point, as Lord Carnworth says, in your paragraph 56 on page 361, and the case cited there.
In the written case. Yes,
Yep,
that's
okay,
right. That's right, my lord.
we have that, okay. Yep.
The issue of the artificial split as well, my lord, which has been quite central to the case of the appellant. Although we do understand that the Supreme Court did not retain that argument, it was not even dealt with at all. And in our humble submission, this is something which was necessary because it would have explained why the fact of having construction material on site would then be treated separately from the cost of construction. There were submissions made on this, and that was not addressed. There is also, my lords, that the issue of materials on site and the relationship that it had with ancillary infrastructure work at subsection 29, there is an open, let's say, rhetorical question asked by the Supreme Court. One is left to surmise as to whether those building materials will be used for the purposes of construction or for ancillary infrastructure work. I humbly submit that it was not up to the Supreme Court to surmise on this. Submissions were made to the effect that these construction materials were not within subsection 29. And the fact of surmising actually begs the question as to, well, what should that quantity surveyor's report contain? We don't know.
Yes, I see. Yep.
As well, there were lengthy submissions made, my lord, on the application of judicial review principles, but having heard your lordship this morning, I think I shouldn't press the point too much. And also, very importantly, my lord, there is no reference, or barely any reference made to the additional stimulus package itself. Now,
The additions to?
in the judgment of the Supreme Court. I can find only two very scant references. One is the introductory line to the judgment, and the second one, which is at page 282 of the record.
Why don't you rely on us to rectify that omission?
Thank you, my lord. I think I have not totally dealt with the issues of, I'm just going through the points I was going to raise. On the issue of cost of construction.
What issue? What's the issue there?
I think I've basically, for the answers and given to lordships, I've probably covered.
Right.
Unless there is anything else that your lordships would like me to address on, I think I would leave matters in the hands of court. Thank you.
Thank you very much indeed. Ms. Pasuman. Thank you very much indeed. We'll retire briefly to consider where we got to, and we'll come back shortly. Court's now adjourned. We'll be back in 5 minutes. Ms. Boulel, despite the engaging way in which you expressed your client's case and the help you've given us, we are not going to call on Mr. Baker. We have been much assisted by not only your oral submissions, but also your written submissions and your written case. And indeed, Mr. Baker and Mr. Ramnall, we have been much assisted by what you say in your written case, and it's partly because it's so clear that in what you say that we don't need to call on you. But in those circumstances, the board will take time to consider their judgment, but we do not call on Mr. Baker. Thank you very much indeed for your help. Court is now adjourned.